Utie oha echi ponkno. Needs FM.
Say clash between legislature and the judiciary. In the legislative arm, any the judicial arm, no, sign and see aircraft. Na nina kwa Mahama Ayariga nsemi ebayi. Yanko na yene council for Mahama Ayariga. Nkwanta secondary school trained, University of Ghana trained, and Makola trained. Na yene nkwachunkomo. Yafen eduji kujo tamaklo. Na yene nkwachunkomo kakra. Lawyer yamwa.
Oh, Sina. Maybe I mean, for you now.
Waye. And Quanta secondary school trained, Legon trained, Makola trained, and answer and they. Right. And Mahama Ayariga could record some of the see, you know, a fambang and a court no say we should allow it to progress on the charge sheet, and a fambang and you see and striking it out.
Yo, Sina. When you say oftentimes now, the criminal process now, the charge sheet now invoke the criminal jurisdiction of the court. And once the charge sheet, which is the process that originates now, the clients mommy express instruction. For the start, we need to raise some preliminary matters. I lay a motion to be moved by me on the 4th of June. And the motion was principally two grounds. One, and it's only part of our name, charges, Martin Alamisti, Amidu, and on a signage charge sheet. We will see an issue. Well, it's already there's a pending matter before the Supreme Court relative to the qualifications or otherwise. Then as two, and the critical issue about the powers of the OSP. When we say Special Prosecutor, Office of Special Prosecutor Act, Parliament passed it. It has not been subject to any judicial scrutiny. And in fact, the first case our file, the criminal case our file, the matter of the Republic versus Mahama Ayariga and one Kendrick Mafu. In the time I charged it by an IS. Now, out of the 5 counts, 4 had to deal with the Customs Act 2016 and the Foreign Exchange Act 2008. I went back to the OSP Act. You see, from the OSP Act, it's clear that the special prosecutor, the powers or remit does not include those offenses. And see, I brought this matter before the attention of the High Court. And see, High Court judge no my essay, racist submission. And see, I call and my lord, they take it, my lady, I take it a few steps. Because the matter is already at the Supreme Court, she cannot make any pronouncement on it, which we definitely agree with that. However, what we indicated to her is that Article 132 now, I stress in the course of any proceeding, if an issue of interpretation arises, you stay your proceedings in mandatory terms. So we urged that on her. She took the view and look, staying the proceedings effectively means that she had injuncted the OSP. So under the circumstance, she will resist the temptation of placing the injunction on the powers of the OSP. So in the circumstance, what she would rather do is that she agrees perfectly with us that 4 out of the 5 counts are not within the remit of the OSP to investigate and prosecute. And so out of the 5, 4 will be struck out, leaving 1 that count 2. Now, it's also important to make the point that, so there are 2 different cases. One involves the purchase of an ambulance. The first accused in that matter is the DP for Boku Municipal Assembly, Honorable Hawa Mutema, a very strong stalwart of the MP in the Boku area. Since she has taken the view that the OSP has the Amidu is a de facto SP, will go ahead with the trial. So basically, that's what happened.
Na dia ne ba ya Mahama Ayariga amount to a boss na or address a court.
No, one will say, I even made it clear to my lawyer. I mean, at no point has Mahama Ayariga asserted immunity from criminal prosecution. Why wouldn't we say under the Constitution, the only person that has immunity from criminal prosecution is man Penny. He's the only one. What I said, he's the only one that you cannot try whilst he holds the office. Even when he leaves office, you can only try him if the matter does not involve an official act. But once it's an official conduct, you can't even prosecute it. So I say, even when he leaves office. So effectively, not your Noah or can be so. There's a certain level of immunity members of parliament or privileges that they enjoy. And the record really shows that it was in the courtroom that he was served, even the charge sheet, by the officer from Yoko, right in front of me. So just here. But what we have said, all this one is that my law should factor the parliamentary duty, even in agreeing on the date for court. And rightly so. My lord, that the 2 adjournments were done and fixed on Mondays, which are days that is not in parliament. So that's what I can say. Now, one will say, initially, I noticed that, let the record also be said that I do not think that there is any such collision, whatever, between the legislature and the judiciary. I think there's look, anytime a Supreme Court judge is to be appointed, so go Parliament, and then Parliament to vet him, so there's that working relationship. I do not think that we've gotten to a point where a suggestion can be made. The certain bad blood between. I think these are matters that can be ironed out.
So, this news reporter out to say the Speaker of Parliament on the second occasion had reasserted the immunity of Mahama Ayariga. Whilst on the second, if I could finish, it's very important to say listeners of the show can appreciate a question that no. Say news reports about Speaker of Parliament having reasserted for the second time the immunity of Mahama Ayariga, and on second occasion, Mahama Ayariga appeared to have done something contrary to the dictates of the Speaker's assertion by mounting the court and admitting that he would respond to the court date as and when it's announced. What do you make of that?
No, okay. The Speaker's ruling. There was a ruling by the Speaker where the Speaker would trace it. And look, after this, who they were near Nanado Dankwe Kupado, our current president, His Excellency. You know, sir, in the early 90s, there was an attempt to arrest him, even as a member of parliament for Buakwa. All attempts to arrest him, he indicated that, look, he was having parliamentary duties. In fact, people jokingly say he even slept in parliament to ensure that he could not be arrested. What am I saying? Okay. It gives you a certain constitutional history where we have come from. Unlike, and the Speaker did, Speaker of Parliament is a lawyer, a lawyer as that. He did a comprehensive ruling. Or Tracy, you know, Australia, they have a specific legislation on immunity of members of parliament, even UK and several other developed countries. What the speaker said is that during the trial of Dana Bodakwi, there was a certain agreement by Peter Lajete and the court. Said Dana Bodakwi will be going to court on Monday. He made reference to all those things. At no point has the speaker said, as Ayariga, he cannot be prosecuted. So honestly, I didn't know what exactly the papers were reporting about. Ultimately, yes.
So in the instance, is it about when Anna Ebeko Supreme Court, if we want interpretation as to whether Mahama Ayariga enjoys a kind of immunity by which court processes, and compromising?
At this point, I'll run away from that question.
Okay, all right. So quick one. Obi the message be the Bremen. Now, a qualified and practicing lawyer, you could be helping me at that. Now, listen, and an appear or Tema Community 7. Or say, Obi a court of competent jurisdiction issue bench warrant. Say, young conco pen, baby, bishi and be a young fan matter, na next court date, no, young fan emramet na honoman. Suppose if we apprehend such a person, is it, could the police grant that person bail? Subject to appearance in court and
there are two things that people confuse.
Yeah.
There's an arrest warrant simpliciter and then a bench warrant. So, for instance, I charge you, I put you before a court of competent jurisdiction. The court has granted you bail. Then you refuse to attend court. The court issues a bench warrant. That court must rescind the warrant. It's different from, say, at this point, a criminal summons has not been issued against you. That's different. So that's it.
It's in the case of Usufampo.
So, like in the case of Usufampo,
just say arrest warrant that was obtained.
Criminal charges have not been filed against him before any court of competent jurisdiction relative to this investigation.
Now, where your bail is granted by the court and you refuse to attend or you fail to attend here.
That one, the court now issues a bench warrant.
Now,
so in that case, when you are arrested in that circumstance, you have to be taken to court.
So when you are arrested in that circumstances, what Nanapia wishes to know, does the police have any inherent power to grant such person bail?
The whole essence of a bail is to ensure the attendance of the person to court. So if the person has demonstrated a capacity to come to court to face the charges, of what use will it be in keeping the person?
The next year say he has a court in the very recent the earlier bench warrant. No,
I do not think so, because the whole essence of the bill is to ensure that you attend upon the court anytime you are called.
Okay.
So if the person has demonstrated a capacity to come to court, the person is not flight risk. It will be our own friend and they'll be back on that. Why should you keep or curtail the person's living?
Oh yeah, into practical approach could also mean that what is a bench warrant near you should know. Now, baby, court will be a not to court to them. And you see, could you tell me, yeah, there was a papa. Right, Mahama Ayariga lawyer.
Utie oha echi punk no. Needs FM.